You know, students, that the Indian government has three main organs: the legislature, the executive, and the judiciary. You have already studied the union legislature, the union executive, and now we are going to begin with the judiciary. When we speak about the judiciary, means we are going to speak about the courts in India. The courts interpret and administer the laws made by the Union Parliament and the state legislature. You know that in India, laws are made by the Parliament and by the state legislatures. When these laws are made by the Parliament and the state legislature, it is then the responsibility of the judiciary to express the meaning of these laws to the people and also to put these laws into practice. In India, the judiciary is divided into three tiers. Right at the top, we have the Supreme Court, which is the highest court in India. Below the Supreme Court is the High Court, and the lowest courts are the session courts. We must remember that the Supreme Court is the highest court in India. The Constitution of India says that the laws made or decided by the Supreme Court are binding on every court in the country. That means every court in India has to follow the decisions taken by the Supreme Court. The Supreme Court of India comprises of the Chief Justice and other judges in the Supreme Court. In the beginning, the Supreme Court had one Chief Justice and 7 other judges. But since the year 1985, this has changed and the Supreme Court has one Chief Justice and 25 other judges. The President of India appoints the Chief Justice of India and also the other judges of the Supreme Court. For a person to become the Chief Justice or a judge of the Supreme Court, he must be a citizen of India, and he must also have at least 5 years of experience as a judge of the High Court or any other court in India. If a person doesn't have experience of 5 years as a judge of the High Court, then he must have at least 10 years of experience as an advocate of the High Court if he wants to become the judge of the Supreme Court. Once a person is appointed as the judge of the Supreme Court, he remains in office till he is 65 years of age. That means he retires as a Supreme Court judge only after he has completed 65 years of age. He can be removed from his post of a judge if he has a record of proved misbehavior. That means if at all he has misbehaved, he may be removed as the judge. Or in case of incapacity, that means if he is not able to work as a judge, then also he may be removed from the office of a judge of the Supreme Court. A judge can be removed from office only after the order of the President. Once a judge has retired from his office after he has completed 65 years of age, he is not allowed to work as an advocate or as a judge in any other court in the Indian territory. Only if his services are needed, then he may be called by the government to work for the court. A judge of the Supreme Court is paid by giving a salary from the Consolidated Fund of India. Besides a salary, he is also given a free house to live in, and many other allowances are also provided to him. It is very important for us to know that the Supreme Court of India is situated in Delhi. If a judge wants to move the site of the Supreme Court from Delhi maybe to another place, he can do so, but with the permission of the President of India. Powers or jurisdiction of the Supreme Court. The Supreme Court of India has the highest power than any other court. For that matter, even the courts in the US. The Supreme Court of India has 3 jurisdictions. First, the original jurisdiction. Second, the appellate jurisdiction. And third, the advisory jurisdiction. Original jurisdiction. This means that the Supreme Court can settle any dispute between the Union government and any one state in India. This means that if there is any fight going on between the Union government at Delhi and any state in India, the Supreme Court has the right to settle this fight. Secondly, the Supreme Court has the authority to settle any dispute that is going on between 2 states in India. Dispute means a fight. Also, the Supreme Court is empowered to decide on any dispute that has arisen out of the elections of the President or the Vice President of India. The Supreme Court is the guardian and protects our liberties and fundamental rights. The Supreme Court is the highest court of appeal in India. By this, we mean that the Supreme Court has appellate jurisdiction. Appellate jurisdiction means that if a person has lost a case in the High Court, he can appeal to the Supreme Court for better judgment. Appellate jurisdiction may be divided into three heads or three categories. First, cases involving interpretation of the Constitution, civil, criminal or otherwise. Second, civil cases irrespective of any constitutional question, and third, criminal cases irrespective of any constitutional question. The Supreme Court has got a power such as review of its own judgment. If the Supreme Court is not satisfied with the judgment given, the Supreme Court may go through the case once again and give a new judgment. This is known as review of judgment or review of the case. You have to know what a judicial review is. Like the Supreme Court of USA, the Supreme Court of India has the right to review the laws passed by the legislature. Review the laws means go through the laws that have been passed by any state legislature. You know that in Goa too, we have the Goa State Legislature, which is situated at Peti. This state legislature of ours also passes laws. So these laws that are passed by our state legislature can be reviewed by the Supreme Court. If the Supreme Court feels that these laws passed by the legislature are not in accordance to the Constitution of India, then the Supreme Court can declare these laws as unconstitutional. Thus, we can say that the Supreme Court is the guardian of the Constitution and the highest forum for its interpretation. This is known as judicial review of the Supreme Court. Another very important jurisdiction that the Supreme Court has is the advisory jurisdiction. Advisory jurisdiction means that the President of India can seek advice from the Supreme Court on any important question of law or fact. The Supreme Court will then give advice to the President, but the advice given by the Supreme Court is not binding on the President. Not binding means he doesn't have to strictly follow this advice. The Supreme Court of India is a court of record. A court of record means all the proceedings or all the cases that have taken place in the Supreme Court are recorded and they are preserved as evidences. Evidences means as proofs. And secondly, the Supreme Court of Record has got the power to punish for contempt. Punish for contempt means if anybody has interfered with these records, the person can be punished. We have finished with the high courts in India. Let us now move on to learn about the subordinate courts. Subordinate courts means the lower courts. Besides the high courts in every state, there are also the judicial courts to administer justice. These courts are known as the subordinate courts, and these subordinate courts, or lower courts as we can call them, are under the supervision of the high courts. That means the high courts take care of these subordinate courts. In India, there are different types of subordinate or lower courts. They are the civil courts, the criminal courts, and the revenue courts. These courts hear civil cases, criminal cases, and revenue cases respectively. Civil cases are cases that deal with property matters. Criminal cases are cases that deal with crimes, murders, etc. And revenue cases are cases that deal with money matters. The court of the district judge is the highest civil court in the district to deal with civil cases. This court is also known as the Court of District and Sessions Judge. The court that you see in Mapsa is known as the District Judge and the Sessions Judge Court. This type of a court deals with both civil and criminal cases. The judge of this court is appointed by the governor of the state. Besides the district courts, there also may be courts of sub-judges in the district. Besides these, there are also family courts that hear cases of divorce and custody of children. Custody of children means that in case parents have taken divorce, then whom do the children live with, the father or the mother? This is decided by the court and it is known as the custody of children. Below the sub-judge courts, there are courts of the munsifs and small causes courts. These courts settle small matters. These courts settle civil disputes or civil fights, and these settlements cannot be challenged in any other higher court. So, once a case is fought in these low courts like the Munsif court or the sub-judge court, they cannot be appealed in any other higher court. Now let us move on to the criminal courts. The court of the sessions judge, known as the sessions court, is the highest court for criminal cases. Criminal cases means cases that are related to crimes, murders, robberies, etc. A district court is known as a sessions court when it settles criminal matters. Below the session courts, there are the courts of magistrate of first, second, and third class. In metropolitan cities like Mumbai, Delhi, Chennai, and Calcutta, the magistrates first class are known as metropolitan magistrates. All these criminal courts can try the accused. Accused means the one who has committed the crime, and give them the necessary punishment as sanctioned by the law. For those who go against the law, any punishment can be awarded except death sentence. A death sentence cannot be given by these courts. An assistant sessions judge has the power to sentence a person to 10 years of imprisonment. A first class magistrate can impose a sentence of punishment for not more than 2 years, or a fine not exceeding 1,000 rupees. Criminal courts hear criminal cases related to violation of law, which include theft, dacoity, rape, arson, pickpocketing, physical assault, murder, etc. In such cases, the accused may be given a punishment of imprisonment, fine, or even a death sentence.